Whether we are in the scientific field, we are the scientists, we are the industrialists, we are the academicians, or we are the students. It is very important how to do the patent. So we have today with us Dr. R.P. Yadav. He is the founder and managing partner for SR for IPR Partners, Patent and Trademark Attorneys. He started his career in 1987 with a reputed intellectual property law firm as an advocate and patent and trademark attorney, and worked for more than 16 years with the firm. He then served National Innovation Foundation, a society of DST, Government of India, as a national coordinator, IPR. Subsequently, he worked with Intel Technology India, a subsidiary of Intel, including Inclusive I USA, as patent attorney for 3 years, an Indian MNC, and lastly, Italian embassy as senior advisor IPR for 2 years. He has thus earned an experience of about 35 years in the field of intellectual property rights practice. Dr. Yadav has obtained special training in Japan as IP protection lawyers in the year 2011 and is an alumni of APIC GIPII Japan. His contribution to an innovation cell of a university has been recognized by MHRD and AICTE's Government of India in the year 2018-19. He has traveled to various foreign countries including US, Canada, China, Thailand, Singapore, Japan, and Dubai to assess viability of technologies to be acquired by Indian companies, to provide opinions in respect of other cross-border IP issues, and to deliver lectures on IPR's Indian system. Dr. Yadav delivers lectures, talks in seminars, conferences organized by MSME and NRDC, TIFAC, CSIR, etc. Sir, we are actually thankful to you. You have accepted our request on a very short notice, and you are ready to deliver a talk, which is very important for all of us. We are thankful to you for your lecture, for your learning, for your experience and the knowledge which will be throwing today to all of us. Sir, we have with us our Honorable Shri B.N. Dikshit Saab. Sir, our former Director Legal Methodology, Government of India. Sir, would you like to speak 2 words before we start, please?
Yes, Ashutosh ji, good morning.
Good morning, sir. Good morning to you, sir. Please.
So, just a few days before we celebrated the Consumer Days, National Consumer Day, and I think that the legal importance of the legal methodology is too much from the point of view of the measurement of the net quantity, because by the virtue of the Legal Metrology Act 2009 and the Department of Consumer Affairs, the peoples are having belief regarding the net quantity wherever they are getting, either through packaged commodity or through any weight or measure or through weighing or measuring instrument. The Legal Metrology Department, Government of India, and the Department of State Government Legal Metrology Departments and the National Physical Laboratories, because the weights and measurement is a traceable chain from international system to national systems and to the ground field working standards systems. So there is requirement of the traceability of the weights and measures. Therefore, all the systems has been made from the district level to national level to international levels. And legal metrology plays very important role. And that's the reason the consumer have belief on the getting the correct quantity through weighing and measuring instrument, weight or measure or prepackaged commodity and all that very things. And we should be thankful to the Department of Consumer, Government of India for the better implementation of this legal methodology Act 2009. I wish for the grand success of these very seminars, and I welcome Mr. R.P. Yadav Sahab. I hope that his lecture will give us some boost to think regarding the intellectual property rights. Thank you, Ashutosh ji. Thank you,
Thank
Yadav
you.
ji.
Thank you
Thank you.
very much,
Thank you, sir.
sir.
Thank
You,
you.
All right.
Thank you.
certainly, this will be very important lecture, sir, and we are really thankful to sir. Sir, with your kind permission, after this lecture, we will share your presentation with all the participants and our online portals, as well as the video which will be recorded of this presentation will also be shared on our platforms, YouTube channel, Facebook, etc. With your kind permission, sir.
Ji, sir. Thank you. Thank you, sir. Can do
Thank you very
can do
much, sir.
that.
Thank you. Over to you, sir. Please. Thank
Yeah.
you.
So good morning, everyone. And thank you, Dr. Ashutosh, for giving a wonderful introduction. In fact, I was told that you have to choose the topic. So what topic I sent to Dr. Ashutosh was that importance of IPR and identification of patentable invention relating to metrological products or process. But then finally, when I came to know that my topic is role of intellectual property rights for scientists, engineers, academia, and industries. So I have tried to connect it with all scientists, engineers, academia, and industries. See, usually what happens, this intellectual property, as you all know, is a property which is generated by applying the mind or your own knowledge in the fields of science, engineering, academia, and industries. Industries means that industries are manufacturing the products. So they are the one who are really providing the products to the public at large for their use. Now, the thing is that why this intellectual property right is so important. As you know, intellectual property is an intangible property and it can be enjoyed like any other property, movable or immovable property. And this was the reason that this is now being recognized all over the world. It was started from European countries, and they came to they ruled us also. UK people, they ruled us also. And this recognition of intellectual property right was started way back. I think thousands and thousands of years back. And if I give you a simple story, that when usually in the past, if you see, the kings used to go for hunting and all that, and they took the complete crew with them. Means uh, people will be there to make the dishes for them for staying and all that. People will be there who will make arrangement for stay and all that. And those khansamas, which we call in English cooks, if the cook has prepared a delicious dish which is being served to the king, and if the king is happy with the dish, he will recognize a particular khansama or cook for preparing this dish even in the future. And this kind of recognition, it was a kind of recognition to a particular cook, because he was now happy that he's the one who will prepare this kind of dish for the king. So this was a kind of recognition since beginning. Similarly, or subsequently, what happened was that scientists came into picture. They were creating discoveries, they were getting Nobel Prize, but monetarily they were not being recognized. So the law came into picture, intellectual property right came into picture, and then government made the rules and regulations that, look, if somebody is doing something new, then he should be recognized in all ways, on social platform, socially, as well as monetarily. And this came into picture that if someone has invented a new product or process, then he should be awarded for that. So what kind of award was given to him? That he or she is the one who will have monopoly rights for a particular time limit. And these monopoly rights will enable her or him to give license to the person who wants to manufacture such kind of product or process. They can sell it once for all, like you sell your property, immovable property once for all. This property, intellectual property, whether it is related to product or process, can also be sold once for all. It can be licensed for getting license fee for years together, like you rent out your house. This can also be. You can use it for yourself. Means as you stay in your house, don't give it to rent or don't sell it. Likewise, this intellectual property, which is related to a product or process, you can use it for your own benefit. So all kind, and for a particular time limit. After the expiry of that time limit for the monopoly rights, every kind of intellectual property becomes a public property. Means anybody from the public can come forward, manufacture that product, or can use the process which is being used for to manufacture a kind of product, and then they can have the monetary benefit for themselves. So particular time limit monopoly rights are granted nowadays everywhere by all countries to its inventors or creators of the intellectual property. Now, see why it is important for scientists, engineers, academia, and industries. Like scientists are the one who knows that up to what extent the work has been done in a particular field. And if it is protected, maybe by way of patent, maybe by way of publication, then it is good for them, because scientists are the one who who will try to find out that up to what extent the work has been done in a particular field, and then they will start the research from that point onwards, reinvent the wheel. So it is important for scientists because it gives the latest informations to the scientists by way of publication and by way of patent system. So patent is also published by each and every government. And you see, if you go to USPTO, you will have all the patent granted for the hundreds and hundreds of years lying on their digital their website. Likewise, India also now everything is now computerized and digitized. So any patent which is granted in India is also available on the website of Indian Patent Office. UK, EPO, UAE, everyone has got their own website, and all the granted patents and published patent applications, the complete data is available, and you can find out that up to what extent or what is the latest invention which has been done relating to a particular technology relating. This is all available nowadays. So it is important for that. Now, likewise, academia. Nowadays, it has been noticed that all the universities, technical institutions, they are being regarded, they are being recognized by NIRF recognition kind of thing. So they also wants to have maximum patents, and this recognition, in other words, this recognition is given to the educational institutions based on the number of patents they have in their own name. So even this is important for academicians, because they are the one who are conducting researches in the institutional institutions, and they something new, they invent something new, and the patent or application is filed in the name of that particular institute in which they are working. And based on that, the recognition is given by NIRF. Similarly, if you go for industry, see this intellectual property rights, they are very, very useful for industry, because industry are the one who are ultimately using the product for the public benefit at large, who are using the processes which are being used for preparing a particular process. And you know it, you know it very well that every day the processes are being invented to make it easy to prepare the product, to manufacture the product. The technologies are coming day by day, they are developing, and they are easing the work of the manufacturer by providing new technology. So it takes less time for manufacturing a product. If you compare 50 years back and now, it is I think 50 times easier now to manufacture a product in as compared with 50 years back. Everything was manual. Now the machines have come up. And what is the how machines have come up? This is all the result of the research relating to the technology. So what industrialists and what scientists, what engineers can do, that they can conduct the prior art searches, maybe on the data available on the patent office websites. They can know that up to what extent the work has been done. They can make the searches on the published data which is available on the platforms like IEEE, like kind of thing. There are so many organizations who publishes the academic research papers, but in those research paper also the informations are disclosed which are relating to a product or process. Now, why this is important for industry is that these informations can be used for improving the existing product, maybe to increase the efficiency or working function or to each operation. You must be aware of Novartis case, where they filed a patent application in India for a kind of medicine which were being used to treat the cancer. But then what they did was that they simply used the derivative of that particular salt which was being used in the prior patent. Subsequently, they filed another patent, but they used what they changed was that they simply changed the derivative. They used another derivative of the same salt, and for which the patent was not given. But if you see, there are so many incidences where the medicines are the efficiency of the medicines are being increased by changing the composition. So in that case, this is very useful for even the pharmaceutical companies. They are increasing the efficiency of their product by doing continuous research and development. If you see the foreign countries like US, they spend money like anything on research and development. And they are the one who are pioneer in each and every field, whether this is relating to technology, whether this is related to pharma product, any kind of product which is for public use. They are the one who are pioneers. We are the one who are still, after having manpower, means scientific manpower, we are number one, I think, worldwide. Nowadays, our people are creating here the technologies relating to software. Software export, India is number one, but we are unable to use it for ourselves. Because here, what usually happens is that we don't spend money on research and development. You all would be aware that brain drain is taking place continuously. And do you know why this brain drain is taking place? Indian scientists, Indian people who has earned their degrees from IITs and IIMs, but they are not able to stay here in India back. Do you know why? Because foreign countries, they give sufficient funds for further research and development, and they make their life easy, but they certainly want best of them. Here our industrialists, first of all, they are unable to employ that kind of genius people, because they don't give a kind of easy life to them. And that is the reason that people are going in the foreign countries. They work for 7 hours, 8 hours, and lead their life very comfortably, luxurious life. But here in India, people have to work hard, like anything. But what they get, just for survival. They are not feeling comfortable, and they go to US, they go to UK, they go every country you see. Indian people are there now. So what we were discussing is that why this intellectual property rights are important for industries, because based on the informations which are already there in the public domain, they can improve their existing products. They can increase the efficiency of their product, and that is now saleable in the market, because user also wants to have efficient product to make their life easy. So they spend money for the latest products which are available in the market, maybe at a larger cost. So industries first do research, they engage people who are involved in research and development, product affordable and efficiency, to increase the efficiency of the product. That's the way that industries are getting benefited, and this role of IPR is very useful for industry. Now, what happens usually is that industries, if you see foreign countries, the companies who are working in the foreign countries, they develop the product, and for developing the product, they go to the people. They want to know that what kind of product public would like to have in the near future. Based on that data, based on the demand by the public, they make new product. And also they will keep in mind that what kind of products are already available, which are being produced, manufactured by their competitors. As I was there in Intel, Intel is the one who manufactures the processors which are being used in computers. You might be knowing every computer has Intel inside, Intel inside, Intel inside. It means that the processor which is used in that particular computer is produced by Intel. And do you know what happens is AMD is also a company. They are also manufacturing the processors. But if you see, and the processor which is being manufactured by AMD is faster than the processor which is being produced by Intel. But Intel's processor is being used almost, if you see the markets here, 60% market share is with Intel alone, because the microprocessor which is being manufactured and delivered by Intel, it is long lasting. And do you know why it is long lasting? Because a technology which is being used to dissipate the heat. When you start your computer, you will see hot air is coming out of it, and fans are being provided just to dissipate this heat. when this processor computer the processors start working, and it transfers, receive data and transfer data in seconds. Trillions, millions of informations are being transferred from one place to another place. Means from the hard disk memory to the other parts of this computer for to make it workable. And this is the microprocessor which works, and there is a lot of heat generated during this transaction. And this heat dissipation technology which is being used by the Intel is the best one. Although the microprocessor which is being manufactured by AMD is faster, it faster than the microprocessor which is being made by the Intel, but it doesn't work for a longer time, because the heat dissipation technology which is being used by the AMD is not so good as or in comparison to the technology which is being used by the Intel. So these are some of the points which I have discussed, that this role of IPR is important to the scientist, because scientists do prior art search and then make strategy, plan their future research. Similarly, it is important for academia, because academia also conduct the prior art searches, come to know that what kind of work has been done in a particular field, and then they start or they plan their research, that okay, from where we should start our research. They would not like to reinvent the wheel. And it is important for industries, because industries also wants to produce the kind of product which are efficient and are useful for the public at large. So this is what is importance of or role of IPR in a nutshell. And then let's go ahead that what kind of IPR is, kinds of IPR, and how it is important for others. This also a role that when you improve the existing product or to make it efficient, make the operation easy. This is also a role. That's the industrial need, and industries, as I discussed, why they want to do all this and what is the role of IPR, because based on the informations which they get in the form of intellectual property right, they can make their product unique. As I gave you one example of microprocessor of Intel and AMD. Increased, as I told you, TAM means total available market. And if you see, it is the Intel who has got maximum market share in regard to microprocessor. And then licensing and cross licensing. You know, this concept of licensing and cross licensing is not well in India. But if you see there in foreign countries, it is well known. The people, okay, let me explain it with the help of a example. Suppose there are two companies, company A and company B. Now, company A owns a patent with regard to an internal combustion engine. And do you know what is the important or heart of the internal combustion engine? This is carburetor. Carburetor is the one who is used to mix fuel with air, with oxygen. And this mixture of fuel, petroleum fuel, is mixed with oxygen or air, and this mixture is supplied to the piston cylinder assembly, which is wound there, and then your engine start working. So suppose company A has got a technology or a patent for a technology which is being used in the internal combustion engine, and this carburetor which is being used in the IC engine is workable only on petroleum fuel. Petroleum fuel means the petrol, diesel, or liquid fuel. Now, company B started research on this carburetor because they want to change this carburetor or work this carburetor for gaseous fuel, CNG, PNG, and all that. So what they did was that they improved the technology of the carburetor, and now this carburetor is capable enough to be employed with the internal combustion engine, and now this IC engine is workable on gaseous fuel. Now, company A and company B. Company A owns a patent on overall technology of IC engine. Company B owns a patent for carburetor only to make the IC engine workable on gaseous fuel. Now, in this case, what will happen? Company A cannot manufacture an IC engine having an improved or invented carburetor which is owned by company B. Company B also cannot manufacture an IC engine even with the invented carburetor because the total technology relating to IC engine is owned by company A. In this case, what happens usually is that company A and company B, they will cross license the technology. So company A will license their technology related to the IC engine to company B. Company B will license the technology relating to the carburetor to company A, and both the company will now start working, and they will manufacture a new kind of engine which is useful for the public at large. So this way, this licensing and cross licensing takes place. And then defensive position also. I don't know whether you people know it or not. Intel has thousands and thousands of patents relating to software. Though this Intel company does work or manufacture the items which are kind of hardware. Is a company who is producing softwares and they are selling the software to the worldwide. But you know, they have thousands and thousands of patents which are related to the hardware. And you will not believe, you might not have seen that Microsoft is suing Intel. Of course, sometime Intel copy or copy the technology, software technology, which is there with Microsoft. Similarly, Microsoft sometime copy the hardware technology, which is there with Intel, but they don't sue each other. And why they are unable to do that? Because people have got or very strong patent portfolio with all these companies have. So they know it very well that if I sue Intel sue me. They will backfire and they will also sue me. So this portfolio or intellectual property right portfolio, they maintain it just for defensive position because they want to save themselves from others and they want to do the business also. So this is the role of intellectual property right. Now let's go ahead. Metrology, what I can tell you, you are the one who knows better than me regarding the metrology. But then I also thought that maybe some of you may not be aware of. So see, this metrology is the science of measurement and usually refer to quality assurance methods used to calibrate the machinery for use to produce goods and or parts thereof. It is advisable to protect and if you invent something new, maybe relating to measurements, quality assurance, maybe methods relating to the machinery efficiency, or to produce the good product, or to produce parts thereof. But if you have done something new, then it is always advisable to protect that technology. Technology may be relating to process or product. Because if you don't protect, cannot say that this is my property. If you own a car, what kind of document you have that I am the owner of this? This is being called as registration certificate, RC, right? RC is the one which is a kind of documentary proof which establishes that you are the owner of a particular vehicle. Similarly, in case of immovable property, suppose you have got a shop or you have got a residential building, what kind of document you will show? It's a kind of sale deed, establishes your ownership on your property. Similarly, if you have a kind of intellectual property, maybe patent, maybe trademark, maybe copyright, maybe design, maybe geographical indication, and if you don't have the proof of ownership with you, then how will you say that this property is mine? So, and of course, let me tell you one thing. Any kind of intellectual property or every kind of intellectual property, it is not necessary to get it registered, but it is always advisable to get it registered, because to have a documentary proof in relation to a particular kind of technology, you have to register it with the state government. Like in India, you have to register it with the Indian government. Indian government means with the control of patents and with the registrar of trademark, with the registrar of copyright, like this. So they are fully owned government of India offices, and they give a kind of registration certificate relating to different kind of intellectual properties, and this is the documentary evidence. So to have the documentary evidence, and you see, let me tell you one thing, why this documentary evidence is required? When there is a litigation, so long as there is no litigation, no kind of document is needed. But when there is a litigation, you might have come to know there are litigation every day with regard to trademark infringement in India. Of course, patent infringement cases are very, very few in India, but you might have seen trademark cases. Like every day, you will see a decision passing on by the Delhi High Court or any other High Court, which is related to the trademark infringement. But then, when there is a litigation, only then these proofs are needed. So it is advisable for the people who are involved in research and development, or who are involved in producing the products which are being sold in the market, and if they are the one who has invented it, or they have owned these intellectual properties from others, then it is always advisable to get it registered, have the documented proof with you. As I told you, that invention may be related to a product or process, and that technology, that novelty, that newness which is there in the product or process is intellectual property. Now let's go ahead. Intellectual property, as I told you in the beginning, and if I tell you in 3 words, creation of mind is intellectual property. And this creation may be related to a product, may be related to a process. Product may be any product, technological product, mechanical product, electrical product. Process may be a process which is being used for manufacturing. Suppose in case of pharma products, see, what has been observed is that pharma products, if you change the process, you will not get the yield which you want. So in pharma products, it is very much necessary to have a specific kind of process which is being used to manufacture a particular drug, a particular pharma product. This may be intellectual property, may be a trademark. We will discuss what is patent, what is trademark, what is design in the next slides. So let's go ahead now. As I told you, why this IP is important. Now, some other importance I will discuss here. That IP, as I told you, IP is an asset, can be exploited by the owner of IP for commercial gains. Another importance, if you get registration, then what IP owner can stop others from manufacturing and selling the product, which are duly registered and protected by the IP owner. So if the IP owner has registration, documentary proof with them, they can stop others, like infringement of trademark, infringement of patent, infringement of design. And IP owner, as I told you in the beginning, IP owner can sell or license their IP for commercial gains. I gave you the examples of house, vehicle, you can sell once for all, you can license it, you can rent it out like this. So these are the importance of intellectual property rights. Some other importance like for academicians, you can very well mention in your biodata that look, I have got so many patents granted in my favor. If I give you an example here, Court Tower, yes, it's a boy whose surname is Kotawar, and he is from Nagpur side. Somebody told him that okay, and he made an invention with regard to IC engine. Somebody told him that you please contact Mr. RP Yadav. We may be able to file the patent application, and you will get a patent. And I filed. These were engineering student, 4 student. They contacted me that we want to file a patent application. We filed a patent application, and they mentioned in their biodata that look, we have worked on a project which was related to IC engine, and we have filed the patent application. And when they completed this degree of engineering, they faced the interview board. And let me tell you one thing, no interview board wants to reject the students like anything. So these interview boards, when they came to know that these 4 people have worked on a particular project and they have filed the patent application, they started asking questions to the individual student regarding that project only. And because these students really worked on that project, they were able to answer their questions. And you will not believe, all got placement in well-known companies. And they came back and they were telephoning me, sir, thank you very much, sir. You filed our patent application and we have got the job. And this Kotawar has now become a entrepreneur now. He has got so many awards from government of Maharashtra. If you see on Google, just write Kotawar, you will come to know about this boy. So what I was discussing is that for academicians, this role of IPR is very important. They can very well mention in their biodata that look, I have done research, I have got so many patents with me. Like IPR certificate, as I said, it's a legal documentary evidence which establishes your ownership on a particular kind of intellectual property. You can very well say that look, this is my property and I have got a proof of ownership with me. Let's go ahead now. Now, this slide, which is Saraswati to Lakshmi. As most of you are researchers doing research and development in the labs, or you have a kind of knowledge with you. Knowledge is obtained by the grace of Saraswati, right? Every institutions, if you see, it's a temple of Saraswati, being called as temple of Saraswati because they give you knowledge. They teach you, and based on the teachings of your gurus, you get knowledge, which is goddess, or which is a quality of goddess Saraswati, who makes you intelligent. But now this intelligence you have, but you are not able to encash it. What we will discuss in this presentation now onwards is that how to use this Saraswati, this knowledge which you have, to convert it in the form of a Lakshmi. Because you know it very well. Nowadays, we have become so materialistic, and nothing can be done without money. You need Lakshmi at each and every step. But then we should be able to know that how to convert our knowledge to earn money out of it. So we will discuss. I cannot guarantee, but I can certainly say that if you adopt these advices, which maybe in this presentation, I think up to some extent you can use your knowledge to earn money. So just see kinds of intellectual property rights. Most of you would be aware of, but let me refresh your memory. Patent. Patent is related to the protection of technologies. So where there is a technological invention, maybe related to product or process, this is being protected under the provisions of the Patent Act 1970. Trademark. Let me give you a little introduction. Trademark identifies the manufacturer of a product. So as soon as you come to know that, okay, Sony is the one who is manufacturing TVs, and the best TV is of Sony, because you know that the picture quality which is being provided by the TV of Sony is the best. And if you go to purchase a TV, you will also like to know to buy a TV made by Sony. So this is the trademark. In other words, it's a kind of brand, and this brand value is created only by maintaining the quality of the product. So if you are able to maintain the quality of the product, then only your brand will become famous. If you degrade the quality of a product, maybe people will say that don't purchase the product which is being manufactured by so and so company. Then design. Design is outer ornamental configuration of an item. You might have seen Bisleri bottle, which is being used to sell packaged water, bottled water. And if you see the design of the Kinley water bottle, it's a different kind of design. So outer ornamental configuration, which you can see from your naked eyes, is design. And this is protected under Designs Act 2000. Trademark is protected under Trademark Act 1999. Now GI. GI introduced just recently in 1999 only. And this GI is the one, geographical indication. So a kind of indication which indicate that this particular product has come from a particular geography, like Darjeeling tea, Kanjivaram sari, Allahabad guava, champagne from a foreign country. These are the GIs. Tirupati's, you might have seen Tirupati Mandir and Tirupati Laddu. This has also got a GI, right? Madhubani painting from Bihar. It has come from Madhubani. Madhubani is a area in Bihar. It's a district, Madhubani district. where the people are staying and they are making such kind of paintings. So the geographic specific product is protected under provisions of Geographical Indications of Goods Act 1999. Then copyright. Literary and artistic work is copyright. Might have seen photographs of Taj Mahal, Agra. So a photographer who takes the picture of this monument in at a particular angle, this photograph is his copyright. He's the one who has clicked this photograph at a particular angle. So literary and artistic work are protected under the provisions of Copyright Act 1956. This act is as old as 1956. There were amendments, but the name of the there were amendments recently also in 2002, then 2013 also. There were amendments in the Copyright Act, but the name of the Copyright Act has been kept as Copyright Act 1956. Then IC, some of you would be related to the computer and computer technologies. IC, the integrated circuit, and you might have seen, and everywhere now you see IC. Your telephone has got IC, your computer has got IC, your TV has got IC. Even the cars now, latest cars, they have got the ICs. So many functions are being controlled not by you but the IC. You simply have to push a button. That's all, nothing else. Just push a button. The things will automatically controlled by the IC. And if you see IC, what is IC? It's a kind of seat which is insulated seat. And if you see on one side of it, all the electronic parts are there, like transistors, triodes, diodes, and all everything. But on the other side, if you see, they are connected with each other. And this circuit, which connects with each component with other component, is the specific circuit. So the circuits which are being innovated for a particular kind of, for performing a particular kind of job, task, this is also an innovation. This is also a kind of intellectual property, which is protected under the provisions of Protection of Integrated Circuit Layout and Design Act 2000. And then plant varieties, you know it very well. This is for the protection of the rights of the farmers, because in the farm also, our farmers, and there are institutions like Agriculture Research Institute. There are so many institutions which are being governed by Government of India just for the development, or for the development of agriculture field and all that. So they are being protected under the provisions of the Protection of Plant Varieties and Farmers' Right Act 2001. And some of you would be aware of trade secret. Trade secret is a kind of intellectual property for which there is no legislation in India. But of course, there is a legislation in US. Trade secret is the one where your intellectual property, but you are able to keep it as a trade secret. No one knows about it, that what kind of this property is. And if I give you a simple example of the chemical formulas of the soft drinks which are being produced and sold by Coke, Coca-Cola, and Pepsi. Softwares, both of these software, if you drink, you will have a different kind of taste. Pepsi has got its own taste. Coke has got its own taste. And you know, these soft drinks, everywhere they are being tried to copy, but the people are not able to have the kind of taste which Coke has or Pepsi has. And you will wonder to know it that only two people in companies know about this chemical formula. And these two people, if they want to, will not fly in the same flight. They are going to attend the same meeting at the same place, but they will go by different flight, because people know it that if they travel along with each other, and God forbid if there is a incidence, untoward incidence, this technology will die for once for all. So they are traveling separately. Is prepared, and then finally one of them will go and mix something which no one knows except him and his colleague, and this generates the taste into that complete dope of soft drink, kind of trade secret. There's no life, there's no limit to the trade secret. This remains your property so long as you are able to keep it secret. This technology goes, as soon as this technology goes in the public domain, you are no more owner of this technology. So that is what is the kind of technology which is being called as trade secret. And all kind of this intellectual property rights are territorial rights. That is, if you have obtained a patent in India, then your rights are protected in India only, not in US. So if your rights are protected in US, suppose a patentee who had patent there in US, based on the US patent, he cannot claim his right in India or in China or in any other country. To protect your right, you have to protect your intellectual property in that particular country. And that is why these rights are called as territorial rights. Let's go ahead. Identify a patentable invention. See, nowadays, most of the technologies are, most of the technological product are based on novel technologies. And these technologies are protected, as I told you, by way of patent. So my intention was that you people are involved in research and development. So what I thought was that, okay, let me inform you that how will you be able to come to know that the product or process which you have invented is a patentable invention. So we will discuss that in every time you don't have to engage patent expert to know that what I have invented is novel or not, means is patentable or not patentable. So I thought that, okay, I will discuss. So what is a patent? In other words, an exclusive monopoly right granted by the state government to the applicant or patent for a limited time of period to manufacture and sell the invented product or process. Now, this monopoly right is granted by the government to the applicant Do you know why? Because this applicant has worked on that invention for years together. Anything to government of India or to registered government. Because as per the Indian Patent Act, best known method is to be disclosed in that patent application. Please excuse me for 2 minutes. I'm coming back.
So I think it is one of the very important topic which is related with each and everybody, how to do the patent. Because I remember with this National Physical Laboratory, I also have some patents, and all the students who are working over here, they are aware of that their professors or their institutions already have their patents in their names. Where whatsoever the next discoveries or next innovations they are doing, they used to get it patented. So it's a complete exercise how it is to be done, how it has to be applied, and it is not a very simple or easy process. You have to go through many complicated steps by which you can get your product or your service or your study patented. But it is very important, and I think that this is one of the important thing by which the companies or the industries are getting benefited. So whenever you're developing something new, you should always consider to get it patented. As we have with us Professor RP Yadav, he's the best known faculty as far as my knowledge is concerned for this particular job, how to get your product patented, how to get your service patented. So certainly it will be good. I think somebody has asked something. What about Chinese product who made copies of product in cheaper price? Yes, a very good point. The point is, they are not copying us; they're copying to all European companies. And how they, because there will be some change, na? Otherwise it is not possible. Sir, one of our participant has asked or raised a good observation. What he says, what about Chinese product who made copies of products in the cheaper price?
Right. See, when I was with Intel in 2004 to 2007, during those days, the Chinese government were encouraging their people to do each and everything kind of intellectual property in China. They simply wanted to have the money. They wanted to increase the foreign reserve, nothing else. Now, but if you see, and during those days, 2004 to 2007, I was there with Intel. The filing, if you see the history, their patent filing was negligible. But do you know, they are number one nowadays worldwide in filing the patent applications. What? And they were very clever. They do research first that what kind of product we can copy, and litigation, legal hurdle. So what the government was doing is the people were employed there that, okay, find out if we want to copy this product and if we want to export it to India, have company got a patent there or not? If you see, they are manufacturing only those items, either they are 20 years old, because the lifetime of a patent is 20 years as a whole, or they are copying only that product not protected by a company in a particular country. China export different product to different countries. So wherever the original owner of the patent, they will copy that product, but they will never export that product to that country where the person has got a patent. No, they will not. They will copy the product, the same product, and they will export this product to a country where this company has not got a patent. And that is what is being done by them still today. Either they will make or manufacture the product on which the patent has already expired, or they will copy the product which is, suppose it is patented in US, then they will copy it and they will sell it to India. Do you know why this? Okay, let me give you a kind of data. See, when I started my practice way back in 1987, 1988, the overall filing of the patent application in India was between 180 patent applications to 220 patent applications all over India. Do you know what is the number now? Anyone can guess? More than 60,000 patent applications are being filed in a year in India. Wonder to know that 70% of these patent applications belongs to either foreign applicants, maybe an individual or company. But you will be happy to know that in these 70% applications which belong to a foreign country, 70% inventors are Indian. As I told you in the beginning, brain drain is taking place. India is the one who has got, or they are, India is number one in manpower worldwide. The youngest manpower India has, no other country has. Even China is lagging. Although the population of China is more than ours, but the young people who are intelligent people can work intelligently. India is at number one. But the only problem is that we are unable to retain that manpower in India. 4 years, 5 years back, I came to know that now Indian people who are NRIs, they want to come back to help India. I think still are not able to come back. And if you see now I came to read an article somewhere in newspaper or somewhere that now people are running, they're leaving this country, they're going to the foreign countries to establish business there, because the environment which is being provided here in India, you see, जो हिंदी में कहें तो लाल फीता सा यहाँ बहुत चलती है. यहाँ पे कोई भी काम आसानी से किसी भी ऑफिस में जाने से होता नहीं है. And if I give you a simple example, my youngest son, 6 years back, he went to the RTO to get a learning license. And you know, he came back empty hands. He said, Papa, वहां तो काम होता ही नहीं, सब पैसे मांग रहे थे लोग, मेरा तो किसी ने एप्लीकेशन भी नहीं लिया. I told him that no, it's not like that. People will be able to help you. You go again. And third time, he was able to get that learning license. और उसके बाद जब फाइनल लाइसेंस लेने की, परमानेंट लाइसेंस लेने की बात आई, ड्राइविंग लाइसेंस, तो आपको पता आया ही नहीं. He went to a tout, gave him the money, and within 15 days, his license was there with him. And then he showed me that, पापा मुझे तो लर्निंग लाइसेंस, परमानेंट लर्निंग लाइसेंस मिल गया. मैंने कहा तुम तो गए ही नहीं. अरे बोले आपने मुझे पहले ही इतना परेशान कर रखा था. अब की बार तो मैंने एक टाउट पकड़ा, उसको मैंने 1500 रुपए दिए और मेरा लाइसेंस मेरे हाथ में. So that kind of environment is there in India still. I'm not saying that bribery is not there in the foreign countries. It is there, but it is at a very high level. Common person, general public don't have to face such kind of humiliation at each and every step. No, it's not. I'm sorry, I'm off track. Have I answered that question?
Yes, sir. Yes, sir. Very well. Now it is very clear. But sir, you kindly check it whether this that particular license given by the Todd is original or not. Because what these people used to do, they just give a fake copies of that.
No, it was not. It was not. It was.
Okay,
It
okay.
was not. It was not. It was
Okay, sir. Thank you. Thank you.
not. Okay. So let's discuss now patent. So what I was discussing is that it's a monopoly right which is being granted by the state government to the applicant in lieu of that all kind of informations are disclosed by this gentleman or gentle lady in the form of a patent application. So the hard work of years together is being disclosed as I told you, that best known method related to that technology, maybe product or process, is to be disclosed in the patent application. And now this right confers monopoly rights on the patentee or the applicant, stop others from manufacturing and selling the patented product, and to use the same innovated product or process for their own benefit or commercial gains. Means the patentee is authorized or authorized to give license to others and to use, they can themselves manufacture and sell the product, patented product or process in the market. So that kind of rights are granted by the patent. Now let's go ahead now. Now, if you see in this slide, I have bold this word invention. Now, if you see what is an invention, if you see general word, it's a kind of making new things in a new manner is an invention. But if you see definition of invention as per the Patent Act. So in general, invention is a discovery related to a product or process. But as per Patent Act, an invention is under section 21J is a product, a new novel product or process. So if your product or process is new, novel, first condition. The second condition is that the product or process involves an inventive step. Inventive step, I will discuss subsequently. Inventive step, here also if I say technological advancement. Condition is that it is capable of industrial application. Means that product or process should be capable enough to be used in the industries, and the product or process should be able to be used by the public at large. So this is usefulness. So any product, process, an invention only when, or is an invention patentable invention only when the product or process is new, novel, it involves an inventive step, that is technological advancement is done, and then this is useful. So if we want to know that whether my product or process which I have invented is patentable or not, what we have to consider these two aspects. Number one, novelty, right? Number two, inventive step. In other words, if I say, so the reference drawn from this previous slide means this slide is that any product, maybe device, machine, composition, any process used for preparing the product is patentable only when the product or process is new, novel, involving an established, non-obvious, and is of industrial usefulness. Here are some examples. Let me tell you one thing. Simplicity is no bar for grant of a patent. My invention may be so simple, but I can get a patent for it. Subject to the condition, if all these previous parameters or conditions are fulfilled. Let me see here. Just see the first picture. It's a kind of rod, metallic rod. Metallic rod made of any metal, but is of no use. Simple rod. Maybe if it is iron rod, then it may be used in the construction of the building. But then what happens was that somebody applied his mind, converted this rod in the form of a sieving needle. Just see the simple needle. And what he did was that he sharpened one end of this rod piece and made a hole on the other end. Now this becomes a sieving needle. And if you see, this is novel. Just see, it's not a simple rod. It's novel item now. Once you convert it in the form of a sieving needle, it becomes a new item, was not known earlier. Technological advancement has been done. It's not obvious. Just see, one end is sharpened. There is a hole made on the other end of this rod to convert it in the form of a sieving needle. Is of often used. बटन टांकना है, थोड़ा बहुत रिपेयर करना है तो घर में ही करते हैं ना, हमारी माँ बहनें सब घर में बैठ के कर लेती हैं, उनको दर्जी के पास जाने की जरूरत नहीं. Now, when this sieving machine came into existence, then there was a need of a sieving needle, another kind of sieving needle, different kind of design of a sieving needle. And what this person did, applied his mind, and what he did was that he made the hole on a sharpened end. He made the hole this time on the sharpened end. And the other end was converted, having a kind of round shape, but then having a kind of channel. And a thread guiding channel also was provided throughout the one end to the other end, so that the thread is guided in this hole and it is put into that hole particularly. And little, if you see in that plunger nozzle assembly of the machine, it is adjusted in such a manner that it doesn't revolve during the sieving process of the taken by the machine. Suppose the other end would have kept round, would not have been fixed with that plunger of the sieving machine. गोल गोल घूमता रहेगा तो मशीन तो चलेगी नहीं ना फिर. So again, this third picture, if you see at the bottom, it's again, now you see whether this is patentable or not. Just see, the item is new. Technological advancement has been done. Channel has been made, and blunt end having a flat surface is made, and then the hole has been made on the sharpened side of it, sharpened end of it. So again, this is novel, patentable. Now, as I discussed prior art, so just see For the third picture, which is a sieving needle to used in a sieving machine, prior art is that simple sieving needle, which is used by hand. For this, the prior art becomes the simple needle. Now, when you want to patent the sieving needle for machine, you have to give the prior art, that why you have to show, you have to establish that this sieving needle is new, novel. And when you establish the novelty, newness, then you have to compare your item with the prior art. Prior art means the product which is already available in the market, right? And then you are able to establish that, look, my product is novel, my product is non-obvious, has technical advantages with it, and then it is useful. What we do when we do prior art search, we just simply analyze these two elements: novelty, newness, and then technical advancement or non-obviousness. Because no one makes efforts for a product or process which is useless. No one. Necessity is mother of the invention. And necessity comes when you want to have certain kind of problems in your life by using a particular kind of product or process. Now your mind start working. You want to avoid, you want to rather fulfill those desires of yours by eliminating the problems which are there with the existing item. If I give you my own example, you will not believe. Till date, I might have drafted thousands, more than 1,000 of patent applications, more than 1,000. But I am not an inventor. I have not invented anything new. But when I joined this Intel in 2004, I'm a delight. Miss, I was staying in Delhi since 1888, because I was trained in Calcutta and then I came back to Delhi, and I joined that law firm LS Davar and Company in 1987 and came back at their office in 1988 and remained here with that company till 2003. But the daily life was that, okay, you go to office, work for the people, work on the applications which are being filed by the applicant, go to the patent office, discuss with the officer concerned, get the patent granted, come back to office, do it. This was the daily routine. Means I was not having time to think over that, can I do something new? No, there was no time. Then I went to government department and I left Delhi, went to Ahmedabad, joined their NIF, National Innovation Foundation, which is a organization owned by Department of Science and Technology. Got some time there and converted, I think, more than 50 innovations in the form of a patentable invention, made the document, drafted the patent applications, and then filed it. So within 16 months with that NIF, I filed almost around 55 cases. Some of them were foreign filing also. Then I left this NIF, joined Intel. And when I was there at Bangalore, I had to go to Bangalore because Bangalore is the research center of Intel. During my days, 2,200 engineers were employed with Intel in 2005. And there, when I was residing, then I was making calls to my mother, to my brother, and all known ones, relatives. And you will not believe at that time, for one call, the charges were 6 rupees for 1 minute. For one call, I think 3 minute call. No, it's more than that. One call were costing us around 100 rupees, sometime 150 rupees, 200 rupees, depending on the time. And for a second, if you increase that 3 minutes of your call for 1 second, the charges were being levied on you for the complete 3 minutes. And then I was wondering, if I have exceeded 1 second or 2 second or 5 second, I have to pay for complete call. And then there was a idea came to my mind that can't we innovate a kind of device with indication before 5 second or 10 second that look, your call is going to be completed within 10 seconds. If you want to continue for another 3 minutes, else drop it. Discuss this idea with my colleague SK Murthy, who did MTech in electronics, and he told me that Ram, this is already there in the market. Like, where is it? Well, let's go to a PCO. During those days, these mobiles were very, very rare. Means these were being used by the big people, but not by the middle class people. So we went to PCO. I made a call to my mother or father, and then PCO, they were having a kind of hard disk kind of thing, and there was a beep. I think before 10 seconds there was a beep, and operator told me, sir, आपका कॉल अगले 5 मिनट में 5 सेकंड में पूरा हो जाएगा, या तो आप कंटिन्यू करना है तो कंटिन्यू कर दूं. तो मैं कहा नहीं मुझे
Sir, we have 15 more minutes. If you please wish to continue or close your complete your topic, it will be very good.
Within 15 only 15 minutes.
Yeah, 15 to 20 minutes, sir. 25 minutes.
Lot of informations are there. Okay, so I will be fast.
No problem, sir. Otherwise, we will be having next lecture very soon.
Can be. So let me go
Please,
ahead now.
please, sir.
So
please.
what I was telling you is that this third criteria, don't bother for that, but those first two criteria we have to analyze just to find out whether the invented product or process is patentable or not. Let's go ahead. Novelty. What is novelty? I told you. Novelty is based on the prior art. Prior art means the product or process is already available. Either it is available in the market, it is in use, or it is published. Maybe in the form of a article or in the form of a patent, because patent specification is published. And this prior art includes printed publication anywhere in the world. You might have made or invented the product here in India, but if the same product is published anywhere in the world, that would be treated as if this is a prior art. So if the complete information are disclosed in that publication, for that publication will become a prior art for your inventive product or process. Prior art does not include technology not known outside of an organization. See, as I was in Intel, there was an in-house circulation. They wanted to tell all the engineers that, look, this work has been done by this particular department. So please don't do any research relating to this particular product or particular process. This in-house kind of publication is not a publication, prior art, because this is known to the people who are working there only. Prior art is the publication which is available in the public domain. So in-house publication is not a prior art. Public display in industrial exhibition, with the consent of the true and first inventor, it's not a prior art. It would not be treated as if this is known to the public because it was only for the exhibition purposes. Publication and invention without consent of the true and first inventor or applicant. Suppose you have invented something new, and there were this was published by your superior, by your head or by your guide, without your knowledge. That will not be treated as if this is a prior art, not publication. The known composition, prior art के example जो हैं वो I'm trying to convince here that suppose there is a composition wherein 3 components has been used, A, B, C, 20%, 30% A, 30 to 50% B, and 40 to 60%. And suppose someone has invented something new. What is that? That is that A is 22 to 28%, B is 32 to 48%, and 42 to 58%. Just see. Limits are lying in the ranges which are given there, 20 to 30, 30 to 50, 50 to so and so, right? This would be treated as if this is a prior art, and this invention is not novel. It is anticipated by the prior composition. Just see the prior art. For the chair, stool is the prior art. For the revolving chair, simple chair is the prior art. And for the wheelchair, revolving chair is the prior art. For the wheelchair, all these 3 chairs, all these 2 chairs, including a stool, becomes the prior art. So these are the examples of prior art. Use these websites, ipindia.nic.in, uspto.gov, epspacenet.com, wipo.org for conducting prior art searches for the patented documents. Inventive step, non-obviousness means no technical advance has been done. If there is no technical advance, there is no inventive step. But if there is a technical advancement done, then there is a inventive step relating to a product or process. So that way you can find out whether my invention is non-obvious or it is obvious. So non-obvious and obviousness is based on the technical advancement and up to what extent those technical advancement has been done, just to remove the disadvantages which were there with the prior art, means which were there with the prior known product or known process. Examples again, engine example, I gave you that engine example, gaseous fuel and petroleum fuel. So this was a kind of prior art and non-obviousness inventive step example. This I think this Gleevec case, Novartis case I discussed in the beginning. So it's the same case of Novartis where it was decided by the patent office that the subsequent product is not a efficient product because they simply use the derivative of the salt. Industrial use, don't worry. Every time there is industrial use, but there are some examples. Just see the first example. It's a cigarette lighting device, convex mirror, fixed with a kind of stand, which is used to light the cigarette. But do you know it is really useful? No, people don't keep it. People keep it either a lighter, simple lighter, or matchbox. Then kind of cloth which may be worn by husband and wife both. Single cloth can be worn by both. But do you feel this is useful in public life? No. Whenever you are there in the house, you can do that, but you can't go out. So it is of no use. There is no industrial use of it. And the third one, ladies usually they love their shoes. And what this gentleman did was that they provided an umbrella on the front tip of the shoe so that it is not damaged during rainy season. But do you think that this is useful? It's not. It's not of any use. So that usefulness is to be considered. Suppose you invent these kind of products which are shown here, that usefulness criteria is not fulfilled, will not be patented here. There's no use. What is non-patentable? That, see, so long we have discussed is that everything is patentable. Every product, every process is patentable. But in fact, it is not so. Every product and every process is not patentable. If I give you certain, these are the laws which are being disclosed in the Patent Act itself. An invention contrary to well-established natural law. For example, perpetual motion, law of perpetual motion, gravitational force. So anything which is contrary to these well-settled scientific principles is not patentable. But it doesn't mean that if these principles are used to invent a new kind of device, then that device will be patentable. Suppose if I am using this gravitational force law, and if I'm making a kind of device which gives me the indication 10 seconds before, 5 seconds, 15 seconds before, that there would be an earthquake, then this device which indicates that there would be an earthquake within next 5 seconds or 10 seconds will be patentable. Like second is invention which would contrary public order or morality, which injurious to human or animal plant life. Suppose if you invent a kind of hard drink, right, which is injurious to human health, you will not get a patent, though it is a new composition, but you will not get a patent for it. Mere discovery of scientific principle of formulation, abstract theory, except non-living substance. Non-living substance, any living or non-living substance occurring in nature. So anything which is there in nature, what you did was you simply isolated it from natural product. You will not get a patent for it. Mere discovery or new property of a new use for a known substance, unless efficacy of that substance is increased. Same principle, composition, efficacy. Like Novartis case, if you are unable to establish the efficacy of a product, you will not get a patent for it. Substance obtained by mere admixture, resulting only in the aggregation of the properties. So suppose there are two, suppose turmeric or neem oil, and if you prepared a kind of balm with the help of turmeric or neem oil, and then, but this balm is nothing but a combination of all the properties which has got turmeric property, neem oil property, composition of those, addition of those properties, you will not get a patent for it. But if by adding these two ingredients, you get a product which has got new properties in it, then you will get a patent for it. Mere arrangement or rearrangement of the known devices working independently. Here I will give you an example. When I was with NIF, National Innovation Foundation, every year there were competitions there. And in one of the competition, I think 2005, there was an entry of 6th standard child. He was studying in 6th standard, and he said that I have invented a walking stick which may be used in the night. And what he did was that he took a simple stick, dynamo on the bottom end of this stick. This connected this dynamo with a kind of storage battery, which he put somewhere in the middle of the stick, and then on the top, near the top end of the stick, he gave a this battery torch bulb. And you know, when you walk with this stick, this dynamo, due to pressure, started working, generated electricity, which was stored in battery, and with the switch, on-off switch, this battery or this torch bulb was being ignited. Here, if you see, it's a mere arrangement of the known devices, right? Mere arrangement or rearrangement of the known devices. Dynamo is known, stick is known, battery is known, torch bulb is known. But if you see, all these three components were working interdependently. If you remove dynamo, the bulb will not light. If you remove battery, if you remove torch bulb, this system as a whole will not work. You will not get, you will get a patent for it. But suppose another example, if I say that I have also invented a walking stick, and what I did was that I went to market, got a dry cell battery, purchased a dry cell battery, clamped this dry cell battery at the top end or near the top end of the stick. When I walking in the night, just switch on this dry cell battery. This is a mere arrangement working independently. There is no connection with walking. This will not be patented. Method of agriculture or horticulture, no patent. Any method of treatment of human being or animal, no patent. Treatment, process of treatment, method of treatment. But if you invent some medicine for the treatment of human being or animal, you will get a patent for the medicine. Not the process by way, plant or animal in whole or any part thereof other than microorganism, you will not get a patent. But of course, microorganism, when modified genetically. So genetically modified microorganism, you can get a patent for it. But if it is isolated, you will not get a patent. Mathematical or business method or computer program per se, program per se, like applications. You have so many applications nowadays, they are not patentable. But if the software is used to operate a particular kind of machine like CNC, right? Computer numerical operated machine, CNC, you will get a patent for that software. Literary, dramatic, musical, artistic work, you will not get a patent for it because there is Copyright Act is there to protect such kind of jobs. Mere scheme or role, method of performing mental act, method of playing game, no patent. Presentation of information, like you have seen my presentation, right? It's a presentation of information. I cannot get a patent for it, but this is my copyright. You might have seen somewhere in the bottom, I might have said copyright RP other. So this is my copyright. I have made it in my own language, in my own words. Topography of integrated circuit, I gave you that IC Act is there. So you will not get a patent for it, but you will get registration under Layout Designs Act. Inventor relating to traditional knowledge, no patent. Traditional knowledge means use of haldi, use of neem separately, no. But if you make a combination, which is a synergistic combination having new properties, you will get a patent for it. Innovation relating to atomic energy, no patent. Section 4 in our Atomic Energy Act, you will not get a patent for any kind of invention which is related to atomic energy. ठीक है, क्विज के लिए तो अब हमारे पास टाइम है नहीं, तो I think this slide you will like most. Thank you. G.
Thank you very much, sir, for your brief and nice presentation. It was one of the best presentation. Actually, sir, this was the last presentation of 2023, and I was considering that this should be, a different type of topic which nobody understand. Nobody, in our community or in our fraternity, very few people understand what is IPR, how to apply. So, sir, now there are two things. There are few things which I would like to ask first. Now, because sir, before that, I would like to request all the participants to kindly switch off their mics and switch on their videos. We are just making all the participants panelists. Kindly switch off their mics, please. Sir, and kindly remove this presentation from the screen. Kindly switch on your mic.
Yes.
Thank you.
Now I can see you all.
Thank you, sir. Thank you. All the participants are requested to kindly switch off their mics.
Yes.
तुलसी किसके माइक से आवाज आ रही है? Yes. Hello. Kindly switch off your mics so that we can speak, we can communicate. Sir, this was the last presentation, so I thought that this should basically be very, very knowledgeable, and people should understand what is required to file a patent. And sir, now my request will be, if you can kindly share us after this presentation, you kindly share us how to apply for the IPR, your numbers, and sir, we will, with this presentation, we will share your number and email ID so that the participants or the industries or the students, academia, anybody who wish to apply for a patent, they can take your expert advice, expert help for making this patent. As you already told us that Rajiv Mehto ji is sharing content. Rajiv Mehto ji, kindly switch off your sharing, please.
राजीव जी आप क्या शेयर कर रहे हो?
Please switch, please unshare kijiye. Yes. So my request is, if you are not able to see, we are making you the party panelist, but request is, if you are not able to switch on your videos, kindly switch off your mic so that we can at least discuss or communicate with other participants. First of all, I would like to thank our today's expert, Professor Arya, who has made this wonderful presentation. Sir, kindly share us the sheets or the basic information which is required to apply for a patent. How to apply? If you just give us basic information, we will share to our all participants. We have very good industrialist. One of my friend, Mr. Ghosh, is there from Kolkata. So, sir, there are a large number of good participants who wish to know what best they can do. Now, over to all the participants. If you wish to ask anything, you are most welcome. But being the last presentation, it was one of the best presentation. Thank you.
Thank you. Thank you. Questions,
Anybody?
please. Questions, please.
Anybody who wish to any question?
अनम्यूट कर लीजिए, जो सवाल पूछना चाह रहे हैं अनम्यूट करें अपने आप को.
Sir, this is the last presentation in this year 2023, and I like to hear you again in the 2024. In the next year, we are just waiting for it, and I pray to Almighty God that everybody in our legal metrology society to grace us from their own heart, whatever positiveness we want in our mind. I pray to Almighty God to bless us all, and to serve our purpose full of positiveness and blessings. And I like to hear you, sir, again, because this is very unknown to the medicine measures society. This is very important nowadays. So I
आशुतोष जी को रिक्वेस्ट करिए, वही तो बुलाते हैं हमें.
No, sir. I will always request the good experts who are available with us, sir. Actually, in India, we have, you told in the beginning, we have nothing which is actually required. We have everything available in our country, and it is in abundance. It is not in small requirement. We have in abundance. So, sir, certainly I will request you. I'm not, sir. I cannot ask you. I can just request you to be the next year. We will again take your help for a brief presentation for maybe 2 hours or maybe more than that. But before that, if you just give us a brief information, what they need before going to apply an IPR, or what are the other things the industries, the academicians or the students can do, you kindly let us know. This will be a very good exercise. And sir, प्लीज
अभी बता देता हूँ.
प्लीज आप मुझे शीट दे देंगे तो बहुत अच्छा रहेगा.
मैं वो भी बना के भेज दूंगा आपको. मैं वो भी बना के भेज दूंगा. अगर आप मुझे 2 मिनट दें तो मैं अभी भी बता सकता हूँ उसे.
प्लीज बता दीजिए सर, प्लीज.
कुछ भी नहीं है घोष साहब. सिंपली हमने क्या किया हुआ है, that what we have done is that we have prepared a kind of questionnaire. So what we do was that we send this questionnaire to the inventor. We ask particular kind of questions. और वहां पे जो information हमें मिलता है, and we have made this questionnaire in such a way that when you answer, you will get all kind of information which are required for drafting a patent application. The thing is done. You just draft the patent specification. Draft it in such a manner that the invention is clearly described in the document, and then file the application along with the government fee. That is what the very simple process Very nominal fee. In case of individual, government fee is 1600 rupees only. In case of company, large company, which do not have a MSME kind of certificate, the fee is 4000.
Okay.
8,000. The fee is 8,000. And of course, the professional fee is different. Now, professional fee, I can't tell you means like this, because every profession, depending on their expertise, depending on their seniority, depending on their work experience, fee varies. Like one advocate can work for 50,000 rupees, another one asks for 5 lakhs. So professional fee, it's not a fixed fee. It depends. But process of filing a patent application or trademark application or design application is not complicated. It's very easy.
Good. Thank you. Thank you very much, sir. Thank you. Thank you for the information. Sir, we will share your presentation. So with this presentation, your email ID and the phone number will be shared with all the participants. And sir, thank you very much. First of all, I would like to wish a very happy and the prosperous new year 2024 because now we will meet in the next year in 2024, and I hope that with the next year we will be meeting in the same way. We will be developing something new things, and next year will be the wonderful year, and I hope that 2024 will be at least 5 trillion economy of the world. Thank you very much. Thank you all. We'll meet next year. Thank you very much. Bye. Good day.